My name is Jeff Morgan. I am from Dallas, Texas. One of the very interesting things that I found is that people talk about the best interest of the child. We need to talk about the best interest of the child. The best interest of the child is that he lives only with mom or only with dad. The best interest of the child is that the other parent who gets deprived of being with the child pays child support and provides insurance. The best interest of the child may be that there be only supervised visitation for the other parent who has never been accused of any type of acts of physical violence. There's no definition for the best interest of the child. In the Attorney General's opinion of February of this year, KP-0241, the Attorney General for the state of Texas talked about factors that may be used to determine the best interest of the child. Now, people who are experts in this, international experts, they will tell you that nobody knows what the best interest of the child is. Everybody talks about the best interest of the child, but nobody has even given it an objective meaning, nor does anybody really know what it is. So when we talk about the best interest of the child, the reality is we are talking about what somebody thinks might be in the best interest of the child. At best, it is a guess. Often, the best interest of the child is determined by a person who does not even know the child. And in many instances, the best interest of the child is merely an opinion asserted by one party. So when I was at this hearing on August 22nd, the attorney for the mother and the stepfather asked the mother, "Do you think this is in the best interest of the child?" "Yes, I do." "Do you think that is in the best interest of the child?" "Yes, I do." "What about this? Do you think this is in the best interest of the child?" "Yes, I do." So there are three things that she asserted were in the best interest of the child. My first thought is nobody knows what the best interest of the child is. The second thing is she offered no proof. She offered no proof. How did you come to this determination this is in the best interest of your child? How did you come to the determination that somehow by having supervised visitations for the father, that is in the best interest of the child, when the reality was you are the one being accused of abuse? When the reality is the medical records show that the son was abused when he was in your possession. How do you get the right to assert the best interest of the child when the police records indicate otherwise? How is this? But the best interest of the child, once again, is a guess. No proof is necessary. Anybody can say, "Oh yes, that is in the best interest of the child. It is in the best interest of the child perhaps for him to never see his father again. Or it is in the best interest of the child to never see his mother again." Whatever the case may be, it's nonsense. The best interest of the child is this. In almost every instance, the best interest of the child is to be raised in an intact family with his mother and father, his natural mother and father. Not a mother and a boyfriend, not a mother and a stepfather, not a father and a girlfriend, and not a father and a stepmother. The best interest of the child in almost every occasion is to be raised in an intact home with his or her natural mother and father. Period. That's it. Once you understand that, everything else becomes clear. Usually the best interest of the child comes into play only when a divorce has been granted or only when there is a child born to two people who were never married. And the judge the judge alone magically can discern what the best interest of the child will be. Even though international experts cannot do so, the judges can make a ruling on the best interest of the child. But the judge is lying, the attorneys are lying. They don't have any idea what the best interest of the child is. Again, if you go back to the simple standard, the best interest of the child is to be raised in an intact family with his or her natural mother and father. Everything would become clear. So for example, when it comes down to an issue of divorce and somebody is saying, well, the best interest of the child is to live with me. If I were the judge, I would say, "Excuse me, ma'am," or "Excuse me, sir. The best interest of the child is to be raised in an intact family with his or her natural mother and father. Because of that, I am going to deny the divorce. You have not given me any credible proof that a divorce needs to take place." In fact, if I were the judge and I had two unmarried people coming in front of me and the mother is saying, "Well, you know, the best thing for the best interest of the child is for the father to pay this child support and for him to only have supervised visitation," or whatever the case may be, if I were the judge, I would say, "Ma'am, excuse me, but the best interest of the child is to be raised in an intact family with his or her natural mother and father. So in accordance with the best interest of the child, I am going to command you and the father of the child to get married, because that is the best interest of the child." Whoa, you're going to say, how can you do that? Well, how can a judge order a divorce knowing full well that it is not in the best interest of the child? The judge is lying to himself. The judge may have been deceived, may have been deluded, may have been fed a line of garbage from these people who purport to know the best interest of the child. Divorce attorneys, they really know the best interest of the child because they can make money off of the best interest of the child. And they can maybe come back later on and say, well, we need to have some more actions taken against this person in the best interest of the child. Now again, the person against whom these charges are being filed may be a completely innocent person, may be a wonderful wife, wonderful mother, wonderful father, wonderful husband, but because one person wants out of the marriage, the judge is going to say, well, you know what, we're going to act in the best interest of the child. The judge is lying. The judge is acting in a manner that is not befitting of his office. The judge should be saying, wait a minute here. You want me to act in the best interest of the child, not in the selfish interest of an adult. If you want me to act in the best interest of the child, once again, you will stay married and you will fix your problems. And if you come back here a second time with this nonsense, one of you, maybe both, will be thrown into jail for contempt. That's the reality of it. The best interest of the child is to be raised in an intact family with his or her natural mother and father, period. Not in a situation which a mother is living with a stepfather or a boyfriend or a fiance or something like that. And by the way, for those who say, well, you know, we've got to keep them away from the father because the father might be a danger to the child. For a child to live in a household with mother and father is much safer by far, than for a child to live in a home with a mother and a boyfriend or a stepfather or a fiance. Statistically speaking, that is the case. There are studies that back this up. The research is solid, rock solid. Not to say that there aren't some fathers that commit physical violence and some outstanding and wonderful boyfriends or fiancés or stepfathers, whatever the case may be. But nevertheless, that is not in the best interest of the child. It's in the selfish interest of an adult. Or let's pretend it's not selfish. It's in the best interest of an adult. Fine. If you are talking about the best interest of an adult, let's be honest. Let's not cloak the best interest of the adult or the selfish interest of the adult and call it the best interest of the child. If we adopted the standard that the best interest of the child is to be raised in an intact family with his or her natural mother and father, and quit making so many excuses, quit muddying the water about this whole thing, a lot of our problems in family courts would go away. And if the judges actually acted with integrity and considered this to be the best interest of the child and made the litigants, or maybe in one case it's just one petitioner, assert the best interest of the child as anything other than that, the judge would say, prove it. Prove it. Lay forth your case that would prove that depriving a child from contact with his mother or her father is in the best interest of the child. When it comes down to a person saying, well, I think I know the best interest of the child, the judges accept that as if it's fact. It's ridiculous. We need to get back to a definition in the Texas Family Code of what is the best interest of the child, because in the Texas Family Code, the best interest of the child is referred to 140 times or more, either directly or indirectly, and yet not once is that defined. And even in the Attorney General's opinion, he gives factors that should be considered in determining, or let us be honest, and trying to determine, or let us be more honest, and guessing, or possibly imposing what one person thinks the best interest of the child may be versus somebody else. And the person who imposes that opinion in many instances is a person who does not even know the child personally, has not met with a child, and it's an abhorrent system that we have here. The best interest of the child is a devilish doctrine that we need to look at. If we want to define it clearly, perhaps we could use it, but right now it is something that is unusable, and it abuses parents and it abuses children. When you abuse children in the name of the best interest of the child, something is terribly wrong with the Texas Family Code, and something is terribly wrong in the state of Texas. Thank you.